the director of the Technology, Media, and Communications specialization at the School of International and Public Affairs. Dean Merritt Jano is our dean, who will be making opening remarks. Last fall, in our class on Zoom, I decided it would be good if we could really look at some of the solutions, policy solutions, affecting journalism around the world, and some of the ideas that have emerged during the COVID pandemic to help support journalism. So with my students, Leah Alaraj, Alan McInerney, Kylie Tumiati, Hannah Clifford, and some others, we wrote a report which was sponsored by the Konrad Adenauer Foundation in the US, and it was called Saving Journalism. And early last fall, I said to Kylie Tumiati, why don't you go check out what Australia is doing? And Kylie wrote a long section on the Australia News Media Bargaining Code and did a lot of interviews. And when we wrote the report, we said, we think this is a really interesting idea that is absolutely worth watching. And I think in the fall, people were thinking about the US elections and they were thinking about COVID, and perhaps it didn't get as much attention as it could have. But once Google and Facebook started to threaten the Australian people, and promising that they were going to drop news if the code passed, interest really was spurred. So we began getting quite a number of press calls, and I wrote an op-ed for the Washington Post explaining the rule. And we thought it would be a really good idea to get Rod Sims and other competition ministers to talk to us about this law, first to hear from Rod about how it works. Then we want to hear from the other ministers about, will it be emulated around the world? And finally, to talk about some of the shortcomings that are worrying people in the journalism community, and to talk about, is the media bargaining code and laws like it the way to go in terms of funding local and independent journalism? So those were our ideas for why to do this panel, because this is a topic that's really galvanizing attention everywhere. And we were sort of flabbergasted and honored and delighted when so many of you agreed to join this webinar, one of the advantages of Zoom. So we have on the panel Rod Sims, who's the chair of the Australian Competition and Consumer Commission. We have Andrea Coscelli, who's the chief executive of the Competition and Markets Authority in the UK. Isabel da Silva, president of the French Competition Authority. Andreas Munt, president of the Federal Cartel Office in Germany. Tembin Kosi Bonakele, South Africa's competition commissioner. And we heard last week from the South African Prime Minister's office talking about their new working group on media that they've started. At the very last minute, we got really lucky because the Director General of Broadcasting Copyright and Creative Marketplace, Owen Ripley from Canada, agreed to join. So thank you for that last minute addition. We're really grateful to you. And helping me organize this is Taylor Owen, who's the professor and director of the Center for Media Technology and Democracy at McGill University in Canada. And then a slew of fantastic student helpers, including Julia Diaz and Alan McInerney. We've got Nadine Tamamli and Rachel Zala from our communications department at SEPA. And we're really honored to have opening comments from our Dean, Merritt Jano, who in fact was an appellate judge in the WTO. So we've got a real group of experts here, and Merritt will open, and then I will ask the first question to Rod Sims. So thank you very much, and to the audience for joining us. We'll be posting the recording on YouTube afterwards, so if you're asleep or busy right now, you'll be able to watch this later. Thank you very much. Over to you, Merritt.
Well, thank you very much, Anya. I just wanted to join and listen to this wonderful conversation and welcome all of you. It's very early here in New York City, but we have fantastic and unique participation from all over the world, Europe, and of course, Australia. On behalf of SEPA, I'm really very delighted that we are hosting this discussion on Australia's new media bargaining code. It's raised a lot of complex questions about the use of competition law and how tech companies compensate media and publishers for use of news content on their platforms. It's gotten widespread attention, of course, with some coming out against and others supporting it. We recently had Brad Smith with us at SEPA, who gave his perspectives around it. Today, I see this as an opportunity for us to learn more about the law, its intentions, its impact, and what it can mean for other jurisdictions. And the interest on the part of other competition authorities to be here, I think, is a statement in and of itself on the kind of interest that it is generating around the world. This is a unique group of panelists, and I'm particularly grateful to Rod Sims for taking time to be with us. I was very delighted to join you, not because of my years on the appellate body, but because of my years in the Department of Justice Antitrust Division, working on cross-border enforcement issues, indeed, with all of the authorities represented here. So it's a particular pleasure for me to hear from the current leadership around the world. For our part at SIPA, I think we're thinking deeply about policy questions between competition and media, as well as digital technology and public policy broadly. And this is related to faculty research as well as training with our students and convening. I want to particularly commend and thank Professor Anya Schifrin, who directs SIPA's specialization in technology, media, and communications, as you heard, who's published a number of volumes on topics of media capture with a very global perspective. And back to you, Anya, with my appreciation and congratulations.
Well, thank you so much, and really so grateful to all the panelists. I think I wanted Rod Sims to begin by briefly telling us about the Australian News Media Bargaining Code, why you decided to use competition law as a way of helping support journalism, if indeed that was your intent, and whether you now that the law has been passed after a lot of back and forth and debate with the companies and with Facebook and Google really threatening to pull news as they did in Spain years ago, and also with the large media outlets who said, wait a minute, this is just going to help Rupert Murdoch, and what about everybody else? So I would love to hear from you on this. Thank you so much. I think you're muted. There
Can you hear me now?
Thank you.
Yeah. Okay. Look, thanks very much, Anya. This is a great initiative, and you've done so much great work in this area. I'm delighted to be involved. And first of all, my profound apologies to all of you in New York or anywhere else in the US for the ungodly hour I've got you out of bed. So I'm pretty sure, looking at the rest of the panelists, it's me who've caused this very early start for you. So apologies. Look, about the code, its objective is to even up the significant bargaining imbalance between Google and Facebook on the one hand and media companies on the other. You'd want a bargain so that the media companies can get value for the content they provide to Google and Facebook, which is no doubt of great value to Google and Facebook. The media companies spend a lot of money to produce that content, and they should be able to negotiate fairly for payment for that content. But it's impossible to have a commercial negotiation with companies that are essentially monopolies, very near monopolies. We're talking about payment for content on search, on Facebook newsfeed, and these are very dominant platforms. Google Search is very close to a monopoly in Australia, and Facebook is very close to that sort of position. So the bargaining imbalance that we're trying to fix is a really important one, because if there's a massive underpayment or no payment for journalism when there should be, that's money that's not going into journalism, and journalism is really of fundamental importance to society, as I know everybody watching this knows. So the model we've used is essentially a negotiate-arbitrate model, where you negotiate, but you've got the ability to go to arbitration. And that's what evens up. It's the ability to go to arbitration which evens up the bargaining position. It doesn't matter whether you do go to arbitration. Most of the time we find in Australia with this mechanism that you don't actually go to arbitration, but that threat, that ability to do it, is what evens up the bargaining power, allows you to have a fair commercial deal, whereas without that potential for arbitration, it would be take it or leave it deals, which is what we'd seen previously. The code absolutely allows large and small players to benefit, and I'll come back to that in a second, but specifically it allows collective bargaining. It allows small players to get together, or any bunch of players, any group of media companies can get together and bargain collectively, and that's certainly what we're going to see. And the arbitration is on the basis of the value, the net value, the value that the platforms provide the media businesses, and what I think is the much larger value that the media businesses provide the platforms. So you ask why competition law? In Australia, and we probably are a bit unique or unusual in this, that we have a part of our act that allows negotiate arbitrate models when you're dealing with monopolies. So getting access to a pipeline, a port, telecommunications is where it all started. A negotiate arbitrate model was used then. And so it was an easy model to come up with well, not easy, it wasn't easy, to come up with to solve the bargaining imbalance issue where the media companies wanted to get paid for their content and they basically couldn't. And the code, by allowing arbitration, is the forcing device that sees a proper commercial deal get done. Let me just elaborate a couple of points, Anya, because in your content, the document for this thing, you mentioned a few criticisms, and I think it'll help explain the code if I just address some of those very briefly. I'll not talk for much longer. First of all, it was said that it only helps large media companies. Well, it actually helps all media companies. There's been deals done between 3 of our major 4 media companies. I'm sure the 4th one will get done. Other media companies, The Guardian, even in Australia, which has got its own 30, 40 journalism outfit in Australia, has got to deal with Google. But a whole lot of companies you've never heard of because they're small, they're independent, they have got deals as well. So it's just wrong, in fact, to say that only the large companies benefit. What is true, and this is a crucial point, what is true is under the code, you will largely benefit in proportion to your contribution to journalism now. That is, you'll get paid, probably roughly in proportion to the number of journalists you have. So it's therefore quite true that the larger companies will get more money than the smaller companies. That's because the objective is to allow a proper commercial deal for content that's now being produced. And so the objective is to get proper payment for content. Now, there's other objectives, like what about trying to promote new media? What about trying to bias towards the smaller media? That's a different objective. I mean, in economics, one of the fundamental rules is one instrument for one objective. So the code is designed to provide funding for content provided now, but you can have other mechanisms to provide money for other purposes. And I think if I have to pick one issue in the document that came out, it did ask the question, is this code the best option for supporting journalism? In my humble opinion, wrong question. The code is part of a suite of measures, and no one measure can solve the issues of journalism, right? You need a suite of measures. And in our report, the Digital Platform Inquiry report, we recommended money continue to go to the public broadcaster. It's one of the top 4 players. It's of equal size of Rupert Murdoch, as is the 9 network, as is the 7 network. They're probably, those 4 are probably of equal size. People can differ a bit, but they've roughly employed the same number of journalists each. They're the 4 big players. But there's a whole lot of other media companies as well. But we recommended you keep funding the public broadcaster. That's a crucial way to fund, and by far the main way Australia funds public interest journalism is to provide $1 billion per year to the Australian Broadcasting Commission. We also recommended extra money go to support local journalism. You could equally have extra money going to support new journalism. So part of a suite of measures. We also suggested tax deductibility for philanthropic contributions to journalism as well. So it's just part of a suite I think, getting journalism right, and it's fundamental that we do, it needs a suite of measures. And look, your last question is, should it be replicated, the code be replicated elsewhere? The key for me, just to finish up, is that there is payment for content. Google and Facebook are using and clearly financially benefiting from the content provided by media. It's important they get paid for that. Otherwise, journalism suffers. Otherwise, we'll have less journalism to the damage of society. The best mechanism for Australia, the code was the best mechanism. I note in the EC and in France, Isabel and I have talked a lot about their model of using copyright. That's fine. My objective is that Google and Facebook pay for the journalistic content they benefit from. Our way of doing that, which we think is best, is a negotiate arbitrate model. But if other models get the objective, we're happy, Anya. So that's my perhaps too long answer, way to kick the panel off.
That was a wonderful answer. So thank you very much for that. And I think you're absolutely right that outsiders forget the other things that Australia is doing to support journalism, including, I think, saving one of the wire services that provides news to lots of small outlets. Another thing, my email, I'm on various listservs, and we've just had the hottest conversations in the last few weeks about the Australian Code. And I was wondering a few things. Free Press has been talking in the US about a tax on micro-targeting and setting aside funding for local and independent news. I was also wondering whether the bargaining code could be modified to maybe even add an extra 2% that would be set aside and distributed to small outlets. You've probably all seen that in Germany, Krautreporter is suing the German government because they're giving money to traditional media and the smaller outlets are saying it's unfair. And then most recently, something I'm writing about right now is this question of tax credits versus vouchers. And what I'm discovering is that economists, and in particular, I've been talking to Julia Cagé and Andrea Pratt, are great believers that vouchers are more democratic, that tax credits end up giving money to the people that are already big or already investing in journalism. Whereas if you give citizens a voucher and let them decide where it should be allocated with a cap, so it doesn't all go to Fox or the New York Times, that might be a more equitable manner of distribution. And I was wondering if you thought of any of those ideas, or if it was just sort of and rejected them, or if it's really outside the purview of competition law, and I shouldn't even be asking a question like that to you or to other panelists.
Oh, Anya, I answer just about any question you ask. Nothing's off limits, but what I'll do here is take my competition hat off and put my economist fiscal policy hat on, if I could. I mean, I think there's a really solid case for government funding, targeted funding of journalism. So we've got the massive funding of the ABC. Some of us would like it to be more, but it's well funded. You're right, we've just put money into the National Newswire service, and that's absolutely fundamental as well. But there's scope for more money to go to journalism. In my view, that should come from the general government budget. Google and Facebook, if they're paying their way through the code, that job is done. Beyond that, if you want to fund journalism, I mean, proper fiscal policy says you design an efficient tax system, and then you raise the money in the most efficient way, and then you allocate it in the best way. And in my view, you'd allocate some of it to journalism. What you don't want is a system where you say, well, what's my need? Where will I find someone to go and tax? You'll just have a mess of a fiscal policy and a mess of a tax system. So Google and Facebook absolutely have to pay their fair share of tax. And there's a lot of work going on internationally to contribute to general revenue. Make sure Google and Facebook pay their tax and pay their full contribution to general revenue. But beyond that, once they've done that, once they're paying appropriately for the journalism that they're benefiting from now, their job is done. I would rely on government spending, funded generally, to support journalism. That's what happens in Australia. The money to the ABC comes from the general taxpayer. The money on the newswire, the money we use to support particular local journalism, all comes from general taxation. My own view is that's the right way to do it.
So then a last question for you before we turn to the panelists is, I think a lot of us who supported the code were all very excited. And then suddenly we thought, egads, in many parts of the world, smaller outlets or bigger ones will end up getting huge amounts of revenue from Google and Facebook. You know, could be as high as 20%. As someone who's edited 3 volumes on media capture, how worried should we be? I mean, if they're getting direct payments from the tech companies, how are they going to be able to resist the sort of soft pressure? Maybe that's the case actually for taxes.
I understand that argument, but look, I think there's still a whole lot of, well, 2 things, I think. First of all, I do think the professionalism of journalism will see the pressure stay on. I know there's different views about how much journalists at various companies follow the party line, but I find in Australia, most journalists will report the news as they see it, and certainly deals have been done with some of the major media companies, but I haven't noticed any change in those media companies reporting on digital platform issues. Secondly, there's a whole lot of other digital platform issues that the media companies are interested in. For example, the ad tech market. So I don't think this is the end of the issue media companies want to get best value for the advertising done on their platform. And that's a big issue for them. So there's plenty more issues, I think. I'm not concerned about that at all, Anya.
Well, thank you. I know that those of us who follow tax avoidance and tax justice definitely felt that the Washington Post, after Bezos took over, did not really cover tax avoidance in the detail that other outlets did. And of course, Amazon is very guilty. But I would love to hear from the other panelists in the room. Maybe first, any other countries represented in this room, are you planning to emulate or adapt the Australian News Media Bargaining Code? Maybe we could start with people first who are planning and then hear from people who aren't.
Maybe if you wish, I can describe what is happening in Europe. Because I do think that there already is an instrument that could be seen as equivalent to the Australian code, although the legal framework is quite different. This is the European Directive on Related Rights, because some of the context that Rod has described as to why there should be a new rule in this context is very similar to what has been taken into account in Australia. Maybe to give you a bit of feedback on why this directive was adopted and what is the system. I think one of the issues that started the debate was the fact that the press was not doing so well in Europe globally, and that we could see that the advertising revenues were regularly going down over the years, and at the same time, the advertising revenues of the platforms were going up very, very fast, but that was not, of course, the only element that started the debate in Europe. There was also the fact that those platforms were using media content and especially press content quite extensively, because you could see in the platforms such as Google, but also other platforms, extracts from press articles, images coming from press agencies. And I think that an interesting thing to have in mind about the European directive that defined a new right that belongs to press editors is that it has not been designed as a tool to support the press. Of course, it is one of the objectives, but the basic idea is that these contents have value, and that to this day, this value was not being remunerated in any direct way. And there was a very strong debate before this directive from actors such as Google saying, I'm helping the press by creating links that lead to the press website. So what is the problem? I am already helping the press editors, but after this very strong debate across Europe, the decision was taken that this value was going without a sufficient protection. And so the choice that was made in Europe was to create a right that is quite similar to copyright, that belongs today to creators, authors, or musicians. And this is something that is very central in the legal system of Europe and beyond. And so this was a very important step. After that, France, that had been quite instrumental in pushing forward this directive, was the first European member state to traduce this directive into law. And a few days after the French law came into effect, we had something that became a competitive issue, because Google announced in France that they were going to keep on using press content on their website, but that all the press editors were asked to agree to allow this use for free. So in effect, if they did not comply to sign a contract giving their content for free, then Google would do away with all the press content on the website. So this represented a quite heavy menace to the press websites that could see a decrease in frequentation of their website and their revenues. So then we have the second stage of this story in Europe that became the competitive complaint in front of the French Competition Agency, and that was really about how Google was applying the law. So it's interesting that it was a copyright law in a way, but we found in our decision of last year that what Google had done and the way Google had done it could constitute an abuse of dominance, because Google had a dominant position in, among other, the market for web searches that is very important in the economic context in France. So an interesting fact is that what started as a debate about value of the press content became a competition issue, because the press editors decided to come in front of the French Competition Agency, and we decided to issue an interim order towards Google, asking Google to enter into a fair negotiation process. And so over the past few months, this process of negotiation has been ongoing. We are now in a new stage of the process, because the press editors have told us they feel that the negotiation was not fair from the part of Google. And in the next few days, we'll have to decide to say whether Google has been complying with our interim order. So the process is still ongoing, but I think it's important to really understand that this new directive and this new law is not designed as a support to the press. Of course, it comes in a context where the press desperately needs to have sufficient funds to finance journalism. And of course, this is also a clear objective of the directive and the law.
Thank you very much. Andreas Mundt, would you like to weigh in here as president of the Federal Cartel Office in Germany?
Yes, Anja, many thanks. I'm afraid we in Germany, we're a bit lagging behind. If I look at the development in France and especially in Australia, which makes me envy to a certain extent that you have already progressed so far, because I firmly believe we must do something about the press. I mean, media diversity, we see that every day now, is really an important issue. And it's the cornerstone of democracy. And I think really something has to happen. I'm a bit doubtful, Isabel, if we can talk about a European development, because the cases that we have seen so far are very much happening at the national level in the member states. What is true is we are all working, or will be working, on the basis of a European directive that is a directive that is valid for all over Europe. But you must see that every legislator in every European country, in every member state, has to transpose this directive into national law. We are just about to do that. The directive legislation is on the way, and maybe we will handle this a bit different from France and other countries, and we will see how far it really gets us when in the very end we want to make one of the tech giants, if we want to make them pay for the content that is provided by media houses. Because if I compare legislation that is just in the Deutsche Bundestag, in Parliament right now, I can only say that in contrast to Australia's new media code, this strengthened copyright that is about to come into force in Germany, it does not include the display of hyperlinks, and it does not include very short excerpts of press articles. From my understanding, this is a difference to the Australian model. Plus, this draft does not provide for any compulsory remuneration. Publishers can decide to make their press products available, yes, free of charge. They can also engage in some sort of collective bargaining, yes, but these are the limits. And I'm kind of wondering where this is going to take us, and if this is really enough of change, if this is enough of the strengthening of the rights and the powers of publishers to go to ask for remuneration afterwards. I must mention another piece of legislation that has just come into force here in Germany. That is a new provision in the German Competition Act. With regard to companies with a paramount significance for competition across markets. Once we have designated companies to be such paramount significant companies, we can prohibit these companies from engaging in certain kinds of conduct. And there's an interesting new provision now in the German law, which says that we may prohibit companies from demanding benefits for handling the offers of another company, which are disproportionate to the reasons of demand. So maybe this is not directed at very first sight at publishers, but of course you can make use of this with regard to the relationship between media companies on the one side and big tech companies on the other side.
Dr. Munch, could you spell that out for us a little more clearly, what that means exactly?
Yeah, what that means. I mean, there are lots of people in Germany waiting that I spell out a bit more clearly what that really means. Because we might initiate proceedings on this basis. It might be, I cannot tell you that. The new law has come into place late January. I think what will be very important in the very end is in which way the legislator indeed is transposing this European copyright directive into German law. I think there is a strong relationship between this. As I said, the copyright directive is in Parliament right now, the transposition into German law. We are waiting for it to come into place, and then we can assess if we might be able to help or to do something for media houses, at least in Germany, on the basis of the combination of this transposed copyright direction plus competition law, as I have just pointed out, which sets a certain parameter and certain standards in the relationship between media houses and big tech in terms of what big tech is allowed to demand from publishers. I think this is the way. It's a bit complicated. Maybe it goes a bit in the direction of what Isabelle was able to manage to do in France. But again, I must say, we are not yet there. We must test it. We must wait for additional legislation, and then we will see how far it gets us. Having said that, I must say, I envy especially Rod for the clear decision of the legislator in Australia, because there has been, in fact, a decision that big tech should pay for media content. And I very much welcome such a clear decision, because of course it helps agencies a lot to go in that direction, instead of combining two different, completely new laws to get that through the courts in the very end. So you ask if we should go in the same direction. I think there are some very, very positive features of Australian legislation, also with regard to arbitration when it comes to that in the very end, because someone has to fix the fees, the remuneration. And we all know, whoever have ever been in such cases, how difficult this can be. So to fix a mechanism for that depends on the parties, that is a huge advantage. So to conclude, yes, there's something going on in Germany. Yes, we look at this very carefully. We are very much aware that something has to happen, but maybe a more clear decision by the legislator, it could be helpful. Let's put it this way.
Well, that's really, really interesting. A lot there to learn from. Fascinating, actually. I mean, it almost feels like there's a couple of different models coming now, right? What Australia is doing, what France is doing. Andrea Coselli, I would have said, let's hear from another European, but now I'll just say, let's hear from someone in the region. You're the chief executive of the Competition and Markets Authority. Where's the UK going with all of this? Obviously, you've been very far ahead of other countries in terms of the white paper on digital harms, the draft legislation introduced in December. How do you see this discussion and this debate? Where do you line up?
So thanks, Anya. I think that's the good way to introduce it, because one of the points here, which is quite interesting from listening to the conversation, is that the Copyright Directive is actually one of the first pieces of European legislation that is not going to come into force in the UK because of the exit from the EU. So in a sense, if you think about the very important case Isabelle is talking about, that's just not an option available to us today, because we don't have that legislation and we're not planning to have similar legislation in the near term. So the situation in the UK, I would summarize in a couple of ways. So first of all, I think the underlying concerns and issues very significantly overlap with what Rod has been talking about, what Isabelle has been talking about. We have done a lot of work as an agency about online advertising, looked into Google and Facebook's position in great detail. And I think we have produced a lot of evidence to support the fact that there is clearly an issue there. And it's a sort of a wide economic issue because you have these platforms with very significant market power dealing with a number of third parties. And obviously publishers and news publishers are a subset of that. So as part of it, we have been talking quite extensively with our government to introduce new legislation through Parliament to give extra powers to a regulatory unit, which at the moment is within our agency, so essentially a regulator, to really deal more effectively and more quickly with a number of the concerns that are coming up. And as part of that, we have been saying to government that there should be a code of conduct, an enforceable code of conduct that would regulate the relationship between these platforms with strategic market status, and Google and Facebook are obviously highly likely to be there, with third parties, including publishers. The government has expressed support for it, and we are currently working with government to prepare essentially the legislation. We expect a detailed piece of sort of consultation document over the next couple of months by government, and then go into the draft legislation process, hopefully at the beginning of next year. In the meantime, we have received some funding from the beginning of this month to set up this regulatory unit in what we call in shadow form, because we don't have the legal powers yet, but we have some funding and there are a number of useful things we can do. So we're supporting the government. We've started working on some of these sort of draft code of conduct, and in particular, the Secretary of State, when he announced a couple of weeks ago the launch of this unit, he specifically referred to this imbalance in the relationship between publishers and platforms, and he has asked us to do some policy work in that area that we are literally doing at the moment. I think it's important to bear in mind that we, in a sense, it's a bit of division of labor. You know, we are an important player in this discussion, but obviously at the end of the day, the democratically elected government must be accountable and responsible for the outcomes across the whole area, including some of the discussions you just had with Rod about taxation and funding. And you know, historically in the UK, there's always been a lot of focus on the media. There is extensive funding of public sector media, various complex arrangements. And in that context, there is a sector regulator, which is called Ofcom, which is a very important media and comms regulator in the UK. And we're working very closely with Ofcom in this space because there are very significant overlaps, and Ofcom will be designated as the enforcer of this online harm legislation when it comes into force, hopefully in the coming months. And again, there are very significant overlaps there, and we've just published some documents explaining how we're working together. We're trying to have very flexible boundaries between the organizations in this area. So I think, as the conversation shows today, there are very significant international linkages. I think the excellent work that Rod and his colleagues have done in Australia is highly relevant for us. It's going to be very, very important in our conversations, our discussions. And I think, as Rod says, the objective is the same. Obviously, different countries have slightly different institutional setups and kind of histories in the way we fund, journalism, and we care about media plurality. The UK has lots of significant overlaps with Australia, so I think it's a very relevant data point for us. Just to conclude, I mean, I think it's a very important debate for democracy. We want to play our part. There are certain, again, as was just said, there are some direct actions we can take already. So, for instance, we launched this investigation into Google in their proposals with the Privacy Sandbox to remove the third-party cookies, which again is relevant for other countries as well, because the same things are happening there. This clearly has a direct commercial impact on third parties. And again, we're working very closely with the privacy regulator on that. And hopefully, we will achieve some impacts there in the coming months. So, as I said, it's a very topical discussion for us. Pretty fluid, certainly playing our part, but certainly we're not going to be the only part of the solution. I mean, others also have to help.
That's actually fascinating, because obviously I've been following the code of conduct, but I didn't realize that could have an implication for some of the things we're talking about here, which is funding for journalism. I think that we're all very curious. We just did an event last week with Rhodes University with a number of scholars, and somebody from the South African Prime Minister's office came and said they've set up a working group on media. And I think it would be very interesting to know from the Competition Commissioner of South Africa, Thembinkosi Bonakele. We often wonder in Southern Africa or in South Africa, to what extent will it be possible or would it at all be possible to stand up against Google and Facebook? And I think that what South Africa does or does not do will obviously have implications for many other countries in the region and possibly in other sort of global majority countries around the world. Can you talk to us a little bit about the thinking in South Africa? I know all of you competition ministers and commissioners talk to each other a lot. Where are you in your thinking about this law in Australia? What might South Africa be able to replicate or not?
Thank you, Anya. I certainly think this is a fascinating discussion and has got a lot of learnings, certainly for me. I think it's early days in South Africa. We've had a commission appointed by government to look at the digital economy. And to be frank, the government commission was not aimed primarily at improving regulation or even curbing abuses emanating from digital platforms. It was more about looking at opportunities, economic opportunities that come with digital platforms. And I think the matters of regulation were kind of an afterthought after we ourselves as the competition authority were involved in consultations with the commission. And that work, they've delivered a report, and that work is still continuing. And we still have a couple of things to be dealt with, including the issues around privacy. We still need to improve a lot on that. And this issue of kind of competition issues emanating from digital platforms, we've confronted it in the main, admittedly through measures, because we really have no choice when there are these measures. And our maiden enforcement case has been on intermediate platforms insofar as they are gatekeepers into markets. And here we were primarily concerned with small and medium enterprises' ability to participate in markets where you have these intermediaries. They have, and we have been following the issues around media and advertising. We think it is early days for us to come up with a view on this. We are organizing a discussion currently with media players and hopefully platforms themselves. And we will be having a university hosting this discussion because we want to have it in as neutral a terrain as possible. I suspect that that is going to be the start of a discussion amongst the role players in South Africa. I think that the kind of intervention in Australia has had definitely an effect in the thinking here. There is some momentum, and I think that we're likely to see some sort of negotiations. Insofar as the enforcement and regulation of this, I think it is very difficult now to see an easy instrument of enforcement rather than your kind of classic abuse of dominance provisions that we have, which can be invoked, but of course, they are incredibly difficult to enforce, as everybody who is an enforcer here knows, but also take a lot of time to resolve matters. But that remains an option for us. I do think personally, though, that and hope that there could be some kind of a regulation around this. I think the issue of media diversity does somewhat go beyond your classic antitrust concerns into the more broader public interest about diversity of opinion and news. So I would hope for a very specific regulatory intervention in that. I think it's possible to do that. I think South Africa is capable of making such an intervention. I'm not saying it's going to be easy. I think we have seen how powerful the platform companies are. Certainly, Australia is quite a well-established country, mid-sized country that we were all kind of surprised by how the platforms were able to flex the muscle against such a powerful state. So there is no doubt that there is a kind of interesting question about the economic power of the platforms vis-a-vis the states. And there are questions about the ability of the states to intervene in that, which brings me to the last point I want to make here, which is that I really believe that these are global questions. I think regions such as Europe are very fortunate to be able to have the European Union that is able to kind of regulate and intervene in a manner that is difficult to resist by anybody. Certainly, if you look at the ability to impose fines by the European Unions, very few jurisdictions, certainly in developing countries, can do that. So I think that the solution, at least in the medium to long term, lies in some kind of multilateral interventions. I think there is a lot of duplication of work, duplication of resources, but also you're likely to see a multiplicity of approaches that I think is going to be, in the end, unhelpful even to the companies themselves. And I think you need some kind of a coordination at this level. Of course, it's very difficult to identify who will do this, but I do think that the existing bodies, UNCTAD, OECD, should, I think, be leading discussions in these. We have sponsored a discussion within the African continent itself that we need to rethink how Africans look at digital markets, because it's going to be very difficult for any African country alone to tackle these matters. It's difficult to build institutions, but I think this is a time where institutions are kind of demanded by the environment that we find ourselves in. I certainly think that the bigger authorities out there would appreciate that it's not enough to resolve these matters internally, that these are global matters requiring global leadership. Thank you.
Commissioner Bonnet-Kelley, thank you for that. I agree completely that we need to see global cooperation and coordination, which is part of why we convened this event. And certainly, I think in the US, where we've really been paralyzed for years, we've all been sort of optimistically looking at Brussels and at France and Germany for solutions. And I would add that in the context of Africa and Southern Africa, the COVID pandemic has been such a disaster for journalism that this is actually a really, really urgent problem. You've seen it described as an extinction event for the continent, that people like Tibanyane have said, we may come out of the pandemic with really no newspapers left in Africa, in many parts of Africa. So I'm glad you're thinking about this. And I would encourage you to, as soon as possible, come up with some solutions for helping preserve the independence and plurality of media. And I know that in many parts of Africa, there's a real suspicion of government involvement, but I think it's just got to be done. Before Taylor takes over with questions from the audience and other questions, I just wanted to make sure we hear from Canada. Did I read somewhere, Mr. Ripley or Dr. Ripley, that Canada is actually considering copying or emulating the Australian law? What I know, Canada's done a huge amount. We have a whole section on Canada written by Hannah Clifford about all the efforts that have been made to help journalism since COVID. But where do you stand on this Australian law? Will you be the next to go for it?
So I think what you've seen the government commit to is a strong commitment to take action in this space. So in the last speech from the throne, which kind of sets out the government's policy agenda for the current parliamentary session, you've seen the government commit to, you know, working to ensure that the revenues of web giants are shared more fairly with creators and media. I think it's indicative, you know, I'm not a competition commissioner. I don't work for a competition authority. And I think perhaps, you know, that's indicative of how Canada is thinking about approaching it. That work has been assigned to my minister, who is essentially the Minister of Culture in Canada. And you're right, you know, Canada, I think, has been reflecting on the issues around journalism for the last number of years. You know, to Mr. Sims' point, you know, this is work that's taking place in a much broader context. You've seen Canada introduce a series of tax measures, labor tax credit on kind of the supply side, a subscription tax credit on the demand side, you know, a tax credit to incentivize charitable giving. You've seen us create a fund, what we call the Local Journalism Initiative, that's designed to support journalists in underserved markets. And then, of course, we too have a strong commitment to public broadcasting in Canada. And so, you know, this piece of the puzzle is one that we're working through right now. And I think it's certainly fair to say that there's been a lot of eyes on Australia in the Canadian context. News Media Canada, which is, you know, the industry lobby for a good chunk of the print media sector, is certainly, you know, indicating that they would like to see Canada pursue the Australian model. The minister, you know, has been careful and clear to kind of talk about a made in Canada approach. And that's because I think all of our, you know, institutions and contexts are different. The Competition Bureau in Canada doesn't have exactly the same kind of mandate that the ACCC has in the Australian context. That has quite a unique mandate. We're currently, you know, engaging with stakeholders on it, and what we've floated out there is, you know, questions about the Australian model, questions about, you know, if Canada was to look at tackling the question of relationship, right? The question of looking at, you know, the imbalance between news media organizations and platforms, and was to pursue an Australian type regime, what the impact of that would be on their business. And then we've also, you know, asked stakeholders about a different approach that, you know, in the Canadian context, particularly the Canadian cultural context, we have a model that, you know, has required certain companies to contribute to cultural policy objectives. And we've seen that in the broadcasting system, where we require our cable and satellite companies to contribute to supporting the creation of Canadian programming. And so we've also asked the question about a model whereby, you know, platforms could be required to make a contribution to supporting the activity of journalism, right? And I think, you know, it's a question, and again, Mr. Sims kind of alluded to this, you know, governments have to kind of ask themselves, what is the policy problem they're trying to solve? And I think, you know, there's the question of, are you trying to lean into the market imbalance, or are you trying to support, you know, the production of the activity of journalism? And depending on the answer to that question, that potentially takes you down slightly different paths. So some of the things that we're just reflecting on, you know, in the Canadian context, you know, having the benefit of watching this play out in France and Australia, is, you know, questions around value. Like, I think you know, the determining that value question is not an easy one in this context. I think we are also very preoccupied in thinking about how you design a system that does, you know, is inclusive of smaller local media outlets. Obviously in Canada, you know, we have 2 official languages, we have Indigenous languages, we have regional communities, and you know, you've certainly seen the community local sector hit very, very hard in recent years. And then finally, I would just say, you know, how do you design a system that is mindful of unintended consequences? And I think something that we're really thinking about is particularly, like, how do you put in place a framework that doesn't you know, incentivize platforms to potentially change the way that, you know, consumers can access news, right? And I think obviously this has come up, you know, in light of you know, Google's reaction to you know, the Spanish model a few years back, in light of Facebook's reaction to what Australia did, right? You know, it would be nice to think you can achieve a framework that is neutral on the question about whether platforms, you know, should be trying to limit access to news or those kind of things. Because I think from a policy perspective, for, you know, with both good and bad consequences, but you know, social media platforms still are a very important vector for people being able to access news, right? And so I think that's something we're also bearing in mind.
Thank you very much for that. Canada really has done a lot, and I think there's so many ideas we can learn from their support for media. Our co-host is Taylor Owen. And I think Taylor had some questions, and also lots of questions. We have a very knowledgeable and expert, esteemed audience of people like Joel Simon and Emily Bell and all kinds of people. So I think, Taylor, you'll ask questions and make sure we get some conversations from the chat as well. Thank you. Yeah,
I mean, I have dozens of my own, but let me pull in some from that have come up in the chat here already. And a couple picking up, Owen, on your mention of negative incentives here, potential negative incentives. And I think one of the things we're clearly seeing is, in response to national regulatory pressure or new legislative pressure, the platforms are reacting globally in ways that often don't align with those potential national regulatory decisions. And one of the ways they're doing it is by a whole new layer of funding agreements with publishers. And we're seeing this applied very differently in different countries, different deals with different publishers. These are generally not transparent. There are different monetary values for different sizes of different markets that aren't necessarily aligned with the size of the markets. And this is really potentially creating a place where significant revenue for journalism is coming from ad hoc deals from publishers. And I guess I'm wondering to what degree you are concerned about that. And is that something that regulators need to align themselves on? Or is this something that publishers need to be more aware of and collaborating on? And to what degree is this sort of reaction from the platforms, who seem to now be okay with putting more and more money into journalism, or be resigned to it anyway, but doing so in a way that is largely ad hoc and outside of the legislative process? I mean, we've certainly seen this in France. So I'm wondering if maybe we could start with you, President Silva. The Google and Facebook have jumped into to fund publishers in reaction to some of this legislation.
Yes, thank you for this interesting question. I think maybe I disagree with the idea that platforms are now very ready to pay for content. And France was a case in point, because one of the issues that came in front of the competition agency was that in effect, Google had decided not to negotiate any price, because Google had decided that all the value of all the different publishers would be zero, and that the publishers would have to accept that. So I think that one very big deal was first to whether Google would enter into negotiations. So that was one of the purpose of the decision that we issued last year. And I must mention also that this decision was confirmed by a court decision last October, which is very interesting in the way it analyzes the issue and the competitive aspect of it. Then comes the next question, which is, what is the fair price? And I see one of the questions from the audience was comparing the figures between France and Australia. I have to say that we don't have the full figure, because they are not in the public domain, because this is a confidential information so far, but it's one of the most difficult issues of this debate. What is the fair price for press content when it appears in the platforms? I think that there are some elements of response in the French law, because the French law is more detailed than the directive, and it gives some references. It says that in some cases, the price can be zero. If the content has no value at all, it appears in very few pages, for example. So we see that one of the elements that the law puts into prominence is the fact that you have a high quality information of general interest could be a criteria for defining the price. So I think it's an important idea that maybe not all press content is worth the same, because it doesn't take the same amount of effort to produce it. And the debate we have had in the negotiation process that we have followed in France is also about what is the relevant criteria to define the price. It can be, for example, the number of clicks that the press content has generated. It can be how many journalists does the press publisher hire and pay daily. So I think that is one of the issues. And another issue that you raise is whether publishers should discuss globally or collectively, or do they go in their own separate ways to try to have the best deal? And what we have seen in France is at the same time some collective discussion with the general interest daily press or weekly press. And we have also seen at the same time some bilateral agreements with some individual publishers. And this has generated per se a debate in France on which was the right way to go to discuss with this platform. So I think we are now really in the midst of tackling these issues, and we will have to decide whether the negotiation has been fair, considering also all these elements. What were the criteria proposed by Google? Were they fair? Were they consistent with the law? The fact that Google had included an offer concerning Google Showcase in the negotiation, was it compliant with our decision? So we will soon have some very concrete answers to these questions. I hope this will be of interest for also the other countries that are undergoing the same process.
Chairman Sims, could I ask you on that? Was there any consideration given to mandatory transparency of any sort of these deals, either to the public or to regulators?
The way it would work is that if they go to arbitration, then the ACCC will see what's going on and be involved. If they avoid arbitration and just use the threat of arbitration to negotiate a commercial deal, then it will be private to them. Having said that, these are public companies by and large, and also you've got our national broadcasters. So I think the amounts of money will come out. There've already been suggestions in the press. So I think the nature of the deals will become more public because we're dealing with public companies. Look, I think just make a couple of very quick comments on that question. I mean, international cooperation is very important, but on the other hand, we can't wait for international cooperation. Isabella's right. Google and Facebook don't want to pay for journalism. There's no doubt about that. So what they're doing is in response to the pressure that's been put on them. And of course, it's in their interest to have an international deal, but that will take forever. I think what you'll find is this is very early days here. It's very early days in Australia. It's very early days in France. I think the nature of these deals will gradually get out there. I think publishers will talk to each other. I think there'll be a lot more transparency in future.
President Mundt, there have been a wide range of reactions from platforms to various German governance initiatives over the past few years, some positive and some negative, I think, in terms of the incentives these regulations have created. How are you looking at that incentive effect?
I mean, what we see in Germany for the time being, and this, I think this is also interesting, is that big tech is already reacting to proposed legislation over here. Yeah. So we have seen contracts, for example. We have seen that Google, as in other countries, by the way, that is not unique in Germany, it concludes contracts with various publishers, including payments for the display of press content. In the Google News Showcase progress, Facebook has done the same, agreements with several publishers in Germany for its new news service. Looking at this, that takes me back to initial question that Anya has asked to Rod, who is benefiting from this? I mean, of course, I believe we must, in the very end, we must take care. Maybe this is a long-term perspective, difficult to say as of today, that all media houses, all publishers benefit from this. Again, here I come back to Australia, where the parameter is how much do you contribute to journalism in your country? I mean, this, to start with, of course, this is an excellent parameter. If you look at it from a competition law perspective, you might want to say it shouldn't be discriminatory. You know, it must be open to all kind of publishers. This is why we monitor these attempts very carefully that are happening over here. Maybe one can make use of it, we will see. But this is something we really need to take a careful look at. I mean, all this is so extremely difficult from my perspective, because I also believe this exercise is changing the game in the internet to a certain extent, because it's for the first time ever. And I think this is why companies are so reluctant to it. It's the first time ever that we break through this everything's for free mentality in the internet. And this is not only a mentality that the user has when he or she is sitting in front of the screen. That is also a mentality that those have who display offers in the internet. And now this is slowly going to change, but it is not a unique or a singular change. I think it is something that changes the nature to a certain extent. And this is why I think you have to overcome so much resistance. And this is why you have to take such a careful look at regulation and how it is designed, again, to make sure that everyone is benefiting properly from what is coming up now.
Andrea Caselli, there's a question here around future-proofing some of these regulatory approaches. There's a lot of focus now on Google and Facebook, but as we know, this landscape changes quickly. And it seems to me that the Digital Markets Unit is an attempt to ensure that the right kinds of data access and forms of transparency are in place to be reactive in the future to future digital giants or digital companies. And can you tell a little bit about what kind of data you will be demanding via that, and how you're looking at sort of the future of the evolution of these companies?
Yeah, so I agree with you. I mean, the idea of future-proofing was very critical and central, I would say, to our work, because the idea is obviously things are changing fast, and they're complicated. One of the debates that I think that the UK Parliament will have to deal with in terms of draft legislation is really this balance between just having very broad principles in the legislation and essentially giving quite a lot of power to the DMU in terms of refining and changing things over time, which probably in many ways would be our preferred option, versus having a more prescriptive approach, which seems to be a bit more the approach at the moment within the European Union with some of the similar proposals. And obviously there are pros and cons to both approaches, because the advantage of the future-proofing flexible one is that it feels a bit more like competition law, which is what all of us kind of do every day, which has the great beauty that you can almost apply to every type of situation. The downside is that over the years has become extremely complicated. And as you see in the US as well, when the US agencies are now trying to bring some of these cases against Google and Facebook, you look at the timetable for the trials and it's years and it's, hundreds of lawyers, thousands of documents, millions of documents. So I think this is a bit the trade-off. The more you want to kind of give discretion to the regulator to really try to fine-tune and tailor the solutions to the problems, but I think theoretically probably we'll all agree with, and in many ways probably that's where we are, the more you run the risk of a lot of complexity and delays and potentially playing into the hands of some of these very big players. So in many ways, it's going to be quite interesting to see that the European Parliament is going to discuss these proposals coming from a slightly different angle. And I see some of the lobbying and some of the concerns have been much more into pushing it in the direction of what we proposed. And I would imagine that some of the lobbying, when our proposal going to Parliament, will be in the opposite direction, that there is a risk that some of these things will take a bit too long. So, it's just a question of balance, and it's a question of, I think, constantly monitoring and thinking about what works and being open to flexing it and to adjusting it as we learn more about some of these markets.
Yeah. Thanks. I mean, Commissioner Berkeley, I think you rightly mentioned the need, particularly for some countries more than others, for there to be international forums for coordination here. And I'm wondering if you'd say a little bit more about what you see as those potential forums. Do you think there are existing international institutions through which these conversations and competition authority coordination could be occurring? Or do you think there's a need for some sort of new coordinating body?
I think the first thing is the willingness of the countries to tackle this. I think you have a lot of developing countries that may think that they are powerless on this. I think it's very important that they get themselves organized into a block here. And this is why I'm saying that we have a huge responsibility in Africa to do that, because these are markets, and certainly some of them are frontier markets that are predicted to grow even larger than some of the existing markets in other parts of the world. So that's the first thing, is just you need a big push, not only by developing countries, but I think also in the interest of really a more equitable world. It's very important for developed countries to also join in this movement for a more fairer sort of participation in the revenues generated from various markets, either through tax systems or sharing with other sectors, as we are now talking about journalism. So there is, I think, a more of a fairness debate that needs to take place globally. You're asking a more difficult question as to which platforms, and we know that there have been challenges with WTO. I think that there is some moves to revive the WTO and its role. I think it is the premier institution that should be tackling these matters. But as I have mentioned, it would be very difficult to move without consensus. The OECD countries, I think, are very, very important for these discussions and for pushing this. So I would hope that OECD can play a role. Bodies interested in antitrust and development, like UNCTAD, also have a role to play. So I think firstly is the movement that needs to be generated, I think, throughout both the developing and developed world.
Thank you. Owen, last question to you before we bring back Dania and wrap things up. Commissioner Sims at the very beginning mentioned that some of these competition policy actions sit inside a broader umbrella of journalism funding. And Canada has done many of those other things over the past few years, the biggest being a labor subsidy for journalists. And I'm wondering, as you think through what sort of competition policy elements might be added to that, how you evaluate that first phase of journalism support policy, and does that, the success of it or not, play in to this current step?
Yeah, I think for sure. I mean, it does play in, right? Because I think the policy objective, one of the policy objectives at the end of the day is asking the question, you know, do we have a sufficient footprint of journalism that's going to hold public officials or decision makers, institutions to account, right? I mean, that's fundamentally what we're trying to do. And I think, you know, at least in the Canadian context, and it's not the same everywhere, but in the Canadian context, I mean, we've benefited from a system that to date, you know, the advertising market has essentially cross-subsidized journalism, right? Classified ads and advertising paid for journalists. So we've never really had to confront the question about kind of what is that footprint and what does it look like? And I think that's, you know, that's the journey that we're currently on in assessing that, right? And those results are starting to come in. Like we have our first results now out from the local journalism initiative in terms of, you know, the number of communities that they supported, you know, and I think some of those are, you know, that is looking very positive, especially considering that, you know, it was, you know, an investment of about $10 million a year in terms of the local journalism initiative. You know, just a couple of thoughts to kind of end on is, you know, you asked about future proofing in your previous question. I would say it goes, but like, yes, we need to think about future proofing from the platform perspective, but we also need to think about it from the news media perspective, right? Absolutely. Because I would say that my hope is that over time we see the emergence of a more sustainable business model in the case of news, right? And it's certainly something we hear from our digital outlets in Canada, who are very, you know, worried about, again, unintended consequences and governments locking in a particular way of thinking about the production of news, right? So the future proofing, I would just say, you know, we need to kind of think about that from both sides of the equation. And then, yeah, obviously the international cooperation piece is key. I think Canada's picked that up to some extent. You know, our minister is championing an international dialogue at a political level with you know, Canada, Germany, Finland, Australia, and France that touches on these issues, that is looking at the question of, you know, platforms and issues around online harms and issues around support for local programming and news media remuneration, to try to build that consensus about, you know, the exact way that each country may approach this will likely look a little bit different. But if we can have some consensus around the principles that we're trying to achieve, then at least, you know, the platforms understand where we're coming from, and from a domestic policy perspective, what we're all trying to achieve, right? And so, you know, I think we certainly understand the need for that, and you know, hope that over the long term that does drive us towards being able to have a more productive, constructive conversation amongst countries, but also with civil society and with platforms about kind of what tech regulation should look like across jurisdictions.
It's a really important conversation. It's the first time that I know of that all of these competition officials have been able to come together, and the joys of Zoom, that we can do it with significant, in the audience, thinkers and doers. We've had the head of committee to protect journalists here. I think we've had a BBC reporter here. We have Emily Bell, who's been a collaborator of Taylor's for years. So we've really got some of the top thinking on this subject from around the world. And I think it's been really important for us to engage with you, because when we hear about the competition ministers, we know you're doing important work, but it's often far away from us. We don't quite understand what you're doing. And so I think one goal was A, to get you all together and explain yourselves and to explain to us. B, to really make sure that you're coordinating with each other. Because what we do see is Google and Facebook are very, very powerful. They throw a lot of money at everybody. Even our own humble world of academia, they throw money at academics, they throw money at startups, they throw money at all sorts of people. They don't really like paying taxes. And when any government agency asks them to do something a little bit differently, to negotiate or to collaborate, they're not really very interested. What they're mainly worried about is their own profits. And then they start throwing money around. They start lobbying and they start handing out money to small outlets that are desperate for money. And so I really think that there has to be a better way. And many of us who are academics or in the journalism development community want that better way. And we're really looking to responsible government leadership to solve some of these problems. How do you get these really rich companies to chip in for news without taking control of the news? And whether it's through the Australian News Media Bargaining Code, in which case it has to be totally transparent, or whether it's other countries saying, hey, we have funds for independent media and you people better contribute, or whether it's just saying, hey guys, it's time to pay taxes. And we're going to take some of those taxes and we're going to support independent media. So I think there's a whole lot of ways that we have to get tech involved in this problem, but not too involved because then they'll take it over. So I think that the work you're all doing is incredibly important. And this is really a plea from the rest of us in the journalism community, in the small communities that have run out of news, and in the tech and policy space, which isn't taking money from Google and Facebook. Like, they don't even return my phone calls, right? And I don't want them to particularly. But what this means is we're counting on you, we're counting on these legislatures to really come up with policies that are going to make sense for the democracy of the rest of the world. So that's a very, very tall order. And I'm really grateful for you to coming and sharing your ideas. We'll be putting this on the cloud and then we'll be putting on YouTube. And I'm hoping that there were some journalists on here and also to publish some of what you said. So thank you very much. And, if some of you talked about the need to convene more, we'd be more than happy with our Little Columbia Zoom account. Taylor's got a Zoom account. Now, why not? Let's convene a monthly call between different regulators who have different questions that they want to ask. And we can bring in academics who've studied this and kind of all sit together and bat out ideas, because I do think sooner rather than later is absolutely crucial. I don't know, Taylor, if you had anything else you wanted to say.
No, just thank you everybody for this wonderful conversation. It was a really
thank you.
Thanks everyone.
Thank you so much, everybody.
Thanks, Anya. Thanks for being together.